And we're back for another episode of Standpoint. I'm Gabe Groisman. So 1 week has passed since President Donald Trump was convicted in New York by 12 jurors in the Supreme Court of New York. That's the trial court of New York City. Of course, Donald Trump is the former president and the current presumptive Republican nominee for president. This has been on the cover of every newspaper in the country and probably around the world. News story after news story have been written about this. We've heard about it on our evening news, our morning news, our midday news. We're talking about it and arguing about it at dinner, at work. But one thing is missing from almost all of these discussions. It's been a week. You know what's been missing? What he's been convicted of. We hear lots of statements about hush money payments and porn stars and Stormy Daniels. But what was he actually charged of? What was he actually charged with? No one could seem to articulate it. So I spent some time digging in to give you guys the answer. This is part of my Quick Point series where I walk through one particular story at a time, break it down, and share with you my thoughts as to why it matters. So, of course, when I was getting ready for this, I started reading news stories, and everybody has a completely different angle on what actually happened. So I went to the source documents. I'm an attorney for over 18 years. I knew I could find the indictments, the jury instructions. So I did, but it's actually on Google. It's unbelievable. You can find them. Somehow, news stories don't even want to link to them. Why, by the way? Because if it doesn't coincide with the story that they're trying to tell you, they're not going to point you to the source documents, but I think it's our responsibility to figure out what actually happened. So here we are. The indictment is in my hands for those of you who are listening and not watching. It's 34 counts. All of them are for the exact same thing, falsifying business records in the first degree in violation of Penal Law 175.10. And every single charge is identical, but for the date and the mechanism. I'll explain. The first one, I'll read it in its entirety. The defendant in the County of New York and elsewhere on or about February 14, 2017, with the intent to defraud and intent to commit another crime and aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen dated February 14, 2017, marked as a record of Donald J. Trump Revocable Trust and kept and maintained by the Trump Organization. The only thing that's different in every single count is the date and the mechanism. The first one, for instance, is February 14th, and it's an invoice. Count 2 is February 14th, and it's the ledger entry for that same invoice. The third count is February 14th. It's another ledger entry. And then there's checks, etc. But the charge is exactly the same. The only difference is the mechanism and the date. So without even going into details, what's immediately missing from the charging document? The complaint, the indictment, the document that tells Donald Trump what crime he's being charged with. The first thing that jumps out is there's no statement about hush money payments, Stormy Daniels, any of the drama we're reading anywhere. It's not there. You know why? Because it's not illegal. Almost every settlement agreement that's ever been signed includes a non-disclosure agreement. You're not going to tell anyone about this. They're not just not illegal, they're common. There's even non-disparagement agreements where you say, I'll give you money if you don't talk bad about me. And if you do, you have to pay me. Again, not just not illegal, not uncommon. The other thing that jumps out, two other very big things, is it says the defendant with the intent to defraud. Who did Donald Trump intend to defraud? It's not in here at all. Now, under the law, I'll share a secret with you. You don't have to say who you're intending to defraud, meaning it doesn't have to be a specific person. It could also be a group of people. So does it say whether it was a group of people? Did it say it was the general electorate? Did it say it was a specific person, a banker? Stormy Daniels, his lawyers? Who was he trying to defraud? Doesn't say it at all. If you think about it, these are internal business records. Here it says, maintained by the Trump Organization. So how could he be defrauding the voters, for example, or potential voters, when potential voters wouldn't have access to his business records? Just not there. The other glaring omission from the indictment, the document which tells Donald Trump, or told him what he was being charged with, through which he was supposed to create a defense and figure out how he's going to defend himself, right? It says, with the intent to commit another crime. Which other crime? It doesn't say. It's incredible. It's a required element in this case, falsifying business records with the intent to defraud. It doesn't say who he defrauded, and with the intent to commit another crime, and it doesn't say which crime. That's just the indictment. But then if you move forward to the jury instructions, and for those who aren't lawyers, just quickly, jury instructions are a set of instructions, rules, a roadmap that a judge reads to a jury after a case is over, meaning after each side presented their case and each side gives a closing argument, the judge then reads a set of instructions to the jury. Now, the way they're put together is that not in front of the jury is excused, the lawyers get to present proposed jury instructions where they agree, and where they don't agree, they have a hearing over it, and the judge gets to rule over which side he wants to take. All reports are that the judge took the side of the prosecutor every single time. I'm not surprised. And I'm not only not surprised for political reasons of the bias of the judge that everybody knows that's listening, I'm sure. But also, if you just read the jury instructions, you will see how one-sided it is. But the first thing, because there are some general instructions that I think is important to point out, is that the jurors were instructed, before you can find the defendant guilty of a crime, and I'm quoting here, the people must prove beyond a reasonable doubt every element of the crime. And remember, the intent to defraud is an element of the crime, and the intent to commit another crime is an element. Now, if the people fail to satisfy that burden, you must find the defendant not guilty. We know that didn't happen. So if we continue looking at the jury instructions, I'm not going to go through all of them, but I just want to lay out the intent to commit or conceal another crime section. First of all, it says clearly that the jury does not need to prove that the other crime was in fact committed, aided, or concealed. They don't have to prove it. It's actually true, but they do have to, the judge would have had to specify which crime they said he intended to commit, because it's an intent. It's not an actual committing of the crime, it's an intent. They don't do that here. But here's what they do try to do, which is very tricky. The jury instructions talk about New York election law 17-152 as a predicate. And it says New York election law provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more parties, shall be guilty of conspiracy to promote or prevent an election. To promote the election, that's language that we've heard about a lot. Why were these business records written the way they were written? Whether it was lawful, whether it was true, or whether it was false, whether it was unlawful, or whether it was lawful. It had to have been done to, quote, promote the election. The second thing it had to have been done, it had to be done by unlawful means, according to New York election law. So now the jury instructions are even more incredible when you read about the unlawful means. Remember, the jury needs to reach a unanimous verdict, but not here. According to the judge and the instructions he gave, and I think this is going to be a big problem on appeal for the prosecution. The jury instructions say to the jurors, you do not need to be unanimous as to what those unlawful means were. Each of you could think something else. Doesn't even matter. You don't have to be unanimous about it. But the jury instructions do lay out some general theories, which is what they call them, of these other crimes. Now, the theories that they say you may consider are violations of Federal Election Campaign Act. Doesn't even say which law, which statute in it. It just talks about how it's unlawful to give campaign contributions more than $2,700 in 2015 and 16. By the way, today it's $6,600. What's missing from it is that when a candidate uses their personal funds for a campaign, they're not subject to any limits. They can give as much as they want. That's not in there. I know that the defense fought to have that instruction in there. I know why the judge wouldn't include that, because that would really screw up this theory entirely for the prosecution. Again, it doesn't lay out any specific crime, civil, criminal, etc. The Federal Election Campaign Act has many parts to it. The next is falsification of other business records, which is obviously circular. And the third is violation of tax laws. Doesn't give any specificity as to which tax laws, other than saying it's unlawful to submit materially false or fraudulent information. Just generally speaking, nothing else. And that's it. That's the entire thing. Now, when you think about what it takes to convict a former president of the United States. It's never been done before. What it takes to convict the presumptive nominee of a major political party or of any political party for president in the United States. It's never been done before. You would think that any honest prosecutor would only bring a rock solid case, would only bring a case that would be really unimpeachable, no pun intended. But that's not what happened here. This is an absolutely flimsy case. Any lawyer who looks at this, who looks at the indictment, who looks at the jury instructions, who listens to the arguments that were made, listens to the evidence, would see this and conclude that it's absolutely nonsensical and wouldn't believe or couldn't believe that this case would be brought. And not only was it brought, but he was convicted. And of course, now sentencing comes, and the judge can do anything he wants. He can sentence Donald Trump to prison. He can do a suspended sentence. He can give him house arrest, or he can let him off, give him probation. He can do whatever he wants. Just think about that for a second. Now, a lot of people talk about threats to democracy, not just in the United States. Here in the United States, the Democrats, it's one of their lines right now during the elections. We can't elect Donald Trump because he's a threat to our democracy. But that's something that we're seeing all over the world in every election, in almost every election, from South America to the Middle East, Israel, the only country there that actually has free and fair elections, to the East. If you don't like what your opponent's saying, you say that they're a threat to democracy. But this perversion of our legal system that we've seen and we've experienced and we continue to experience is exactly what a threat to democracy is. This case and the upcoming sentence is a true threat to our democratic republic. Here's why. Alvin Bragg and Judge Mershon have proven that our otherwise amazing system, our otherwise amazing democratic system, where we have a division of power between the federal government and state government and local government, decentralized power. We have laboratories of democracy with different states passing different laws. Of course, the boundaries are protected by our U.S. Constitution and the federal government, supposedly. We have different court systems, state court systems generally to deal with local disputes with elected prosecutors. A true judiciary system that really is supposed to keep our country in balance. All of that is our democracy. Of course, in addition to free elections and a free press. But all of it can be held hostage, like it has been, by rogue actors from within the system, by prosecutors all over the country, by judges. And the fallout from this case will be felt for years, mark my words. This country has a risk of devolving into what we see in so many other countries in Latin America, in Europe, in Africa, where when a new president is elected, the first thing they do, they appoint their judges, they appoint their prosecutors, and they go after the other guys. Or worse, or maybe just as bad, when there's an election that's contested, somehow someone gets charged with a crime, ginned up charges, put them in jail. And that's what we're seeing here. And this isn't going to be the end of it because they've opened the door. They've opened Pandora's box. And that's something that's terrible for all of us. So much so that I frankly do not know the way out other than what we've learned in this country through civics, which is the only way to make change is at the ballot box. There should be a political price to be paid for these activist judges and activist prosecutors. We know that there's a lot of money behind these offices trying to sow chaos in our society. We have to fight back. We have to push back at the ballot box. We have to dig for the truth. We can't just take what we read in the media to be true. Look at this case as an example. You have to dig for the source documents. You got to research yourself. Yes, it takes more work, but it's our responsibility and it's our country. So let's get out and vote. Let's get activated and let's make a change to save our country. Thanks so much, and I'll see you next week.